Arizona has quietly hired a war chest and a team of lawyers, and it is getting ready to do something that has not been done in a serious way in living memory. It is preparing, right now, to take the fight over the Colorado River into a courtroom, potentially suing the federal government and possibly other states over who has to give up water as the river dries up. This is not an idle threat muttered in a press conference. The state has set aside millions of dollars, retained one of the most powerful law firms in the world, the kind that defends banks and oil giants in their biggest cases, and openly stated it is ready to file if it does not get a fair deal. And here is why that matters far beyond Arizona. For 100 years, the Colorado River has been governed by a fragile set of agreements that the 7 states honored, however grudgingly, precisely because no one wanted to gamble everything on a judge. If Arizona actually sues, that century-old truce breaks, and the future of water for 40 million people could be decided not by negotiation, but by a court. This is the story of why Arizona is loading its legal weapons, what it is actually fighting about, and why the moment it files could change everything. Before going further, it is worth being precise about where things stand, because the details matter. Arizona has not yet filed a lawsuit. What it has done is prepare for one with unusual seriousness, creating a dedicated legal fund worth millions, hiring elite outside counsel, and stating publicly that it is ready to go to court if it must. Officials have suggested that if a lawsuit comes, it could arrive within months, depending on what the federal government decides. This is a loaded weapon that has not yet been fired, a threat made deliberately visible so everyone at the table understands it is real. Whether it is ever used depends on the choices the other states and the federal government make in the months ahead. To understand how it came to this, you have to understand the deadline the entire river is racing toward. The set of rules that currently governs how the Colorado River is shared, how the reservoirs are operated, and who absorbs shortages was written years ago and is set to expire. For years, the 7 states that share the river have been negotiating what replaces those rules, and they have failed, repeatedly, missing one federally set deadline after another. The core of the deadlock is a bitter split between the two halves of the river. The lower basin states, Arizona, California, and Nevada, sit downstream and have already been absorbing cuts as the reservoirs fall. The upper basin states, Colorado, Utah, Wyoming, and New Mexico, sit upstream where the river is born. And the fight is brutally simple. Who takes the cuts? Because the federal agency that manages the river put forward a set of proposed alternatives, and Arizona looked at every single one of them and saw the same thing. The cuts fell on the lower basin. The upper basin was asked to give up little or nothing. To Arizona, that was not a compromise. It was a demand for surrender. It helps to understand just how high the tension had already climbed before the lawyers were hired. The negotiations had dragged on for years, past one deadline in the late autumn and another in the depths of winter, with the 7 states unable to bridge the gap between the two basins. Each missed deadline eroded a little more trust, and in the spring, the federal managers took a step that Arizona regarded as something close to a breaking point to protect the upstream reservoir. They announced they would cut the amount of water released downstream, holding more water in the upper basin's Great Lake and sending less down to the reservoir that Arizona and its neighbors depend on. Arizona's water agency responded by calling this a failure to comply with the bedrock agreement among the states, language that, to anyone who follows water law, sounded a great deal like the opening notes of a legal complaint. It was a signal that Arizona no longer saw the process as a good faith negotiation among partners, but as a situation in which its fundamental rights were being violated, and in which it might have no choice but to defend those rights in the only venue left. So Arizona did something telling. It stopped just negotiating and started preparing for war. The state set up a multi-million-dollar legal fund and hired a global powerhouse law firm, the sort of firm that handles multi-billion-dollar corporate disputes, specifically to fight over the Colorado River in court. The governor's office made the strategy plain. Arizona would much prefer a negotiated deal that protects its fair share, but it must be ready to defend itself in court if an agreement cannot be reached, or if it believes the fundamental law of the river is being violated. In other words, Arizona is not eager to sue, but it has decided it will no longer be the state that quietly absorbs the deepest cuts while others give up nothing,